Assalamualaikum to everyone. Today we will have a talk session on art and copyright law as part of research in program for postgraduate student in USM. So this will also be airing live in Facebook at Arts USM. Our topic today will be art and copyright law. I think this is a discussion not always touched on, at least in USM. And today we are delighted to have with us Mr. Lee Khai, a practicing lawyer from Ong and Manecksha. Okay. In Penang Art Scene, Mr. Lee Khai needs no introduction. He is the chairman of Penang State Art Gallery. Been invited for the coming Art Penang Festival as co-curator, which is to be held in 2021. He is also an avid art collector, and I was privileged to get to see his collections of artwork displayed in his office building in Penang. Today, Mr. Lee Khai will give a talk on art and copyright law. There will be some general information on copyright law regarding artworks, some samples of cases regarding imitations, appropriation, and parody, and some tips for copyright holders. At the end of this session, at the end of this talk, we will open this session for questions and answers. Both questions and answers can be asked directly. If you want to ask, you can switch on your microphone and video. In the meantime, you can switch off your microphone especially so that we won't get interference of noises. Questions can be asked both in English and Malay. And you can ask from Facebook Live, or you can ask directly, or from the chat box in Cisco Webex. Okay, Dr. Sina will be monitoring questions from Arts USM Facebook, and she will cue me for the questions. Okay. In the meantime, when Mr. Lee Khai is talking, if there are any terms that you are not familiar with or something that you need Mr. Lee Khai to clarify, you can ask in the chat box, and I will ask Mr. Lee Khai to explain more. Okay. So the rest of the question can be kept at the end of the session. So let's have Mr. Lee Khai with his talk title Art and Copyright Law. So Mr. Lee Khai, you can start whenever you're ready.
Thank you, Dr. Tetriana. Dr. Serena is also online. Thank you for inviting me for this talk. It is a peculiar time of the day, 5:30 to 7 for a talk. I hope that I'll be able to keep you interested. I will try not to make it too academic so that we can keep some interest going. You can see my slide. My slide is on. So the topic is on art and copyright law. Let me start by telling you a story about a famous trial in history involving art and artists and art critic. It was not about copyright law, but it is an interesting case with food for thought when we consider creativity in art, which is of underlying importance when we discuss about art and copyright law. In 1878, the American painter James Abbott McNeill Whistler sued the eminent art critic John Ruskin for libel, for defamation, because of harsh review by Ruskin. Ruskin at that time was England's leading critic during the Victorian era. He was a widely trusted authority on taste, on good taste. Whistler was American. He settled in London in the 1860s, and very quickly he became a central figure of the British aesthetic movement. The group championed the idea of art for sake. It was something new then. Whistler's painting style emphasized on mood and tonal harmony above all else. So he names his painting with names like arrangements, harmonies, symphonies, borrowing terms from the music world. So Ruskin saw Whistler's work, this one on the screen on the left-hand side. It's called Nocturne in Black and Gold, The Falling Rocket, done in 1875. And it was shown at the gallery called the Grosvenor Gallery in London, where they show modern artwork that has been rejected by the Royal Academy of Arts, deemed not good enough for the Royal Academy. And the painting was priced by Whistler at 200 guineas. And the painting depicted fireworks exploding over the Thames with the glitter of the falling sparks in the night sky. And the work is part of his series called Nocturnes. So Ruskin reviewed the exhibition in his monthly periodical. He's one of the earliest blog writer, right? His periodical was called Force Clavigera. And this is what he said of Whistler's Nocturne. He said, I've seen and heard much of Cockney impudence before now, but never expected to hear a coxcomb ask 200 guineas for flinging a pot of paint in the public's face, right? For flinging a pot of paint in the public's face. So the trial lasted for two days. The lawsuit spurred debates about the value of art, the role and the creative freedoms of artists, the role of art critics in society. Ruskin got the Attorney General, Sir John Holker, to represent him in court. He also got the pre-Raphaelite artist, Sir Edward Burne-Jones, to give evidence for him. So the parties debated in court on a range of issues, from Whistler's artistic philosophy, the merits and the fundamental rights of critics and artists. And Burne-Jones, when he testified, he said that Whistler's Nocturne was a beautiful sketch, but that is not alone sufficient to make it a good work of art. He said it is deficient in form. The form is as essential as color. So during his cross-examination of Whistler, Holker asked Whistler, how long did it take him to knock off one of these paintings? So when Whistler responded that it took just 2 days, Holker asked if 2 days' labor was worth 200 guineas. Whistler said, no, I asked it for knowledge I have gained in the work of a lifetime. So while Whistler ultimately won the case, it was lost on both sides. It's a lose-lose situation. Whistler actually wanted the damages of £1,000 in addition to his court costs, but he was only awarded 1 farthing. 1 farthing is the smallest coin that you can find in the British Empire then. It is 1/4 of a pence. There were 240 pence in a pound, and he got 1 farthing in damages. The art journalist Jonathan Jones says, Ruskin represented high modernism, and Whistler stood as first in the tradition of low modernism. That low modernism ran through people like Duchamp, Dali, to the present-day artists. So this Whistler and Ruskin trial represent a pivotal turning point for what is meant to be a critic and an artist. So Ruskin's criticism, one widely accepted by the Victorian public as truth, now is seen just as a matter of personal opinion. And many have noted Whistler. Whistler is a new type of artist. He's the one which is into public personality, branding. And he is seen as an early precursor to people like Andy Warhol, Damien Hirst, and Jeff Koons. All these characters are very prominent when it comes to copyright law, because they always embroid themselves in various types of litigation. That's a long introduction. Let's go right into the topic as to what is copyright. Now, this is taken from the Copyright Act of Malaysia. Copyright covers a wide range of things. Right? Works are, literary works, musical works, artistic work, film, sound recording, broadcast. When you say artistic work, if you draw a stick figure, it is considered artistic work. It can be copyrighted, right? You have a copyright that the Malaysian law specifically says that the work are protected irrespective of their quality, right? And for the purpose for which they were created. And copyright does not extend to ideas. You cannot copyright ideas. Dan Brown, if you remember this author, he's the author of the book Da Vinci Code, which eventually made into a famous Hollywood movie. Dan Brown was accused of stealing the idea for his book from a 1982 non-fiction book called The Holy Blood and Holy Grail. The author of the book Holy Blood and Holy Grail were Richard Lee and Michael Bajan. They sued Dan Brown for breach of copyright of taking their ideas. They lost the case because you cannot copyright ideas. Because if you do that, you actually impede, right, creativity. Law is all about how society works, right? So the law cannot be so strict that it impedes the working of society. So as long as there was no verbatim copying of someone's words or someone's work, then there is no breach of copyright. Now, copyright gives you exclusive control. If you have copyright, you have exclusive control of how that work is to be used. How is it going to be communicated to the public? Right? If it's a dance, how is it performed? If it's a music, how is it played? Whether you can make copies, whether you can make money out of it, right? Those are the right of a copyright holder. Now, what is artistic work? Let's go to that again. Artistic works covers a wide range of things, like I mentioned just now. If you draw a few lines purposefully, those can be copyrighted. So graphic works, photographs, sculptures, irrespective of artistic quality, right? Doesn't matter that you like it or not. Work of architecture, a building, all right? Someone owns a copyright. But the interesting later thing is, later we'll see whether how you copy the copyright, right? It cannot be too strict. Then if it's too strict, then you have a problem. If you take a photo on the street, will you be sued? If the building owner say, you've taken photos of my building, I own the copyright, right? So later we'll see that. How long does copyright last? In Malaysia, it is the life of the author plus 50 years. Now, different countries have different durations. In this world, generally, it is life plus 50 years or life plus 70 years. And generally, it's these two. The UK, the US, even our neighbors, Singapore, Indonesia, they provide for life plus 70 years. Now, what happens after that, life plus 50 or 70 years? After the expiration of a copyright, the work is now called to be in the public domain. So you hear of the term public domain. Means that no one owns a copyright anymore. Do you need to register your copyright? Copyright, unlike trademark or patent, you don't have to register your copyright. Right? Once you created that work, you have the copyright in it. But in Malaysia, we do have something called the registration under copyright voluntary notification regulation of 2012. This is a platform for you to register your copyright. Basically, what it does is that it provides a platform where people will be made known that I'm first in time. I've done this. I want that copyright to be recognized, right? But whatever you register with this regulation, it is only prima facie proof. That's a legal term. When I say prima facie proof, meaning if I go to court, if I show you that I've registered this regulation, it shows that I may have a good claim. If you cannot show a better claim, then I have a good claim. But someone can always come and show that, hey, I've done this earlier. this exact work was done by me earlier. Then your registration, you took my copy, you copied my work, and then you register it. So if someone can come and prove that, that prima facie proof is now rebutted. So that's so long and short of it is that in Malaysia or in the world, you do not have to register your copyright. It's all about proof, whether you can prove that that is your work and you're the first one who came up with it. Who owns copyright for commission work? Basically, the law is if you commission someone to work, right, to come up with a work, the person who commissioned owns the copyright. Or if, for example, you work with USM, you write something during the course of the employment, that piece of work, the copyright would belong to USM, unless otherwise agreed upon. Right? That means you can make a contract to say, no, that presumption doesn't apply, I own the copyright. So basically, if you go to a gallery and buy a painting of the wall, you may own that object, that artwork, right? But you don't own the copyright. The artist still own the copyright, unless the artist sell you or sign the copyright to you. Right? So that is the general case. That is why in recent years, many museums, I've dealt with museums in this region, where when they acquire the artwork, they did not get the copyright from living artists, or artists have died less than 50 years. So they are going around to get that license or the copyright to those works. Are you familiar with this face? This is an interesting case. It's called the monkey selfie case. What happened was David Slater, he's a nature photographer. He's British. He went to Indonesia. He spent some time in Indonesia's forest, and he befriended this group of Celebes crested macaque, this monkey that you're looking at. So he set up the his camera system in the jungle, and he left it there. And the monkeys came, and monkeys started operating the camera and start taking selfies. So it looks very comical, it looks very interesting. So Slater actually published it. And soon he found that there were many of these monkey selfies. He found that these photos went to Wikimedia Commons. Wikimedia Commons is a platform where supposedly works without copyright are being posted, right? And then it also went to a blog called TechDirt. There is a US NGO called the People for Ethical Treatment of Animals, PETA, P-E-T-A, the People for the Ethical Treatment of Animals. They also joined the fray, and they argue that the monkey should own the copyright, not David Slater. Now, David argued that he has a valid copyright because he engineered the situation that resulted in the photos being taken. Right? Like I mentioned, he went to Indonesia, he took effort to meet this group of mole monkeys, he set up his camera equipment so that the selfies can be taken by the monkeys. But Wikimedia Foundation refused to remove the pictures from Wikimedia Commons image library. And sorry, did something happen to my slide sharing? Let's see. Let me go back to, okay. So Wikimedia argued that since the monkeys took the photos and monkeys are not legal person, therefore monkeys cannot hold copyright, then the images should be Slater say that as a result of this picture being put on Wikipedia, he has lost £10,000 or more in income, that it's killing his business as a wildlife photographer. In 2014, the United States Copyright Office made a statement that works created by a non-human, such as a photograph taken by a monkey, are not copyrightable. But a number of legal expert lawyers in the US and the UK argued that his role in the photographic process is sufficient to establish a valid copyright claim. But for such opinions to count, a decision has to be made by a court of law. But Slater did not sue Wikipedia. Interesting thing is that the story did not end there. Slater, the photographer, published a book containing these monkey photographs through a self-publishing company called Blur. In September 2015, PETA filed a lawsuit in the US against Slater and Blur, claiming that the monkeys should be assigned the copyright and that PETA should be appointed to administer the proceeds from the photos for the monkeys' benefit. So the court who heard the case dismissed PETA's case, and the court ruled that in US law, a monkey cannot own copyright. After PETA appealed before it was being heard, PETA and the photographer Slater agreed to a settlement where Slater agreed to donate a portion of his profit to wildlife organizations. But the US Court of Appeal refused to let them withdraw the appeal or refused to vacate the lower court judgment. So this is a rare occasion where the court say, no, you cannot withdraw, you cannot settle, we're going to go ahead and hear the case and give our decision. So finally, in April 2018, the US Court of Appeal affirmed that animals cannot legally hold copyright, and actually expressed concern that PETA's motivation is to promote their own interests rather than actually protecting the legal rights of animals. But the peculiar thing is that since Slater did not sue, the court also did not say that the copyright belongs to Slater. Right? So it just decided that monkeys does not own copyright. So that's interesting. Until and unless such case crop up again and goes to court, we still don't have a final legal answer on that. Now, exceptions to copyright. Very often you hear the term fair dealing or fair use. These two terms may overlap because they are defined or they are used slightly differently in different countries. The US Supreme Court, in the case of Stewart and Aben, explained that fair use as a doctrine permits court to avoid rigid application of the copyright statute, when on occasion it will stifle the very creativity which the law is designed to foster. What it basically means is that copyright law is not to stifle creativity, it's actually to protect creativity. So this law cannot be so strict that it will stifle copyright law. That's why the lawyers came up with this idea of fair use or fair dealing. So it should be noted that copyright law aims to balance the interests of copyright owners for protecting their original work, as also, on the other hand, accommodate the interests of the public for having reasonable access to copyrighted works of. Our Malaysian Copyright Act lists the exception and limitation to copyright. You see here, the exception includes the use of copyrighted work for research, for private studies, for criticism, for review, and for reporting of news or current events. So if you do such things and it happen to include other people's copyrighted work, it does not infringe that person's copyright. So in determining whether the use of the work in any particular case is fair use, different factors, a few factors are to be taken account. I can list 4 of them. One, the purpose and character of the use, including whether the use is for commercial nature or is it for non-profit educational purpose. Two, the nature of the copyrighted work. Three, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, how much you copy, right? And four, the effect of the use upon the potential market for value of the copyrighted work, how much of this use of the copyrighted work will affect the original author's commercialization of his copyright. So let's look at some examples of how copyright law is at work. Before that, someone said this: copying is the lowest form of creativity. How much can I copy? That's where you differentiate between these two terms: reference or derivative. So take, for example, this photograph of a butterfly. Take this photograph and look at photograph, and you take ideas from the color of the wings of the butterfly and come up with your new work. That is called referencing. But if you slavishly copy this entire photograph of a butterfly as your artwork, then it is considered a derivative work. If it's a derivative work, then you may be infringing someone's copyright. Okay, so this difference between them. Now, a derivative work is frowned upon ethically. Sometimes it may not infringe someone's copyright, but when someone look at it and know that you very much copy someone else's work or get performance as work, then that's frowned upon. Some people will say, oh, as long as you don't copy more than 10%, you'll be all right. In law, there's actually no such hard and fast rule. Later, we'll see, look at a few cases, and we'll see how it is applied. Maybe a good question for you to ask is, how would I feel if someone copied my work? And the other thing that I can say is that there are actually a lot of free materials available out there. You don't really have to copy people, right? You go to a website like Flickr, and Wikimedia Commons. You pretty much can use the images there for free. And there are some conditions that they attach to it, but pretty much you can do it for free. Now, let's look at this case. The case of Rogers and Coons. Art Roger was a professional photographer. He took black and white photo of this man and woman with their arms full of puppies. The photograph was titled Puppies, and it was used on greeting cards and other merchandising. Jeff Koons, you know the name Jeff Koons. Jeff Koons is a renowned artist. He's actually the world's second richest living artist. The first is Damien Hirst. He found the picture on the postcard, and he wanted to make a sculpture based on the photographs for an art show on the theme of the banality of everyday items. So what he did was, all this came out in court. He removed the copyright label from the postcard. He gave it to his assistant and gave them instruction as to how he wants the sculpture done. Jeff Koons is famous. He's got a factory. Works may not be done by himself. He's got assistants to do it. And he said that he wants as much detail be copied as possible. But he wants a puppy to be blue. He wants their noses to be exaggerated. He wants flowers to be added to the hair of the man and the woman. And he came up, his factory came out with this sculpture called String of Puppies. And it became a success. He sold 3 of them for a total of $367,000 Roger sued Kunz and the gallery for copyright infringement. Kun admitted that he copied the image intentionally, but he said that he has a defense of fair use by parody. The court found that there was substantial similarity between the two works, and Kun had access to the picture. These are the conditions for copyright infringement. First, you have access. That means you have seen the original artwork, and then you copy substantially. Right? So theoretically, if you come up with an artwork that you have not seen anyone else do, but one day someone actually came out and showed exactly the same thing done earlier than you. Theoretically, if you can prove that you have no access, there's no way that you have ever seen the other person's work, then both of you has your copyright on your own work. It's possible to have such a situation. Now, in the case of Rogers and Kun, the court found that the similarity between these two was so close that the average lay person would recognize that there was copying by one of another's work. Right? So the sculpture was found to be a copy of work by Rogers. The court rejected Kun's parody argument because Kun was not commenting on Rogers' work specifically. To be a parody, you should be referencing the original artwork and so-called making fun, giving criticism, commenting on the original artwork. That is the purpose of parody. Right? So the court found that Kun's work did not fall under fair use exception. Before the court decided how much Kun should compensate Rogers, they reached a settlement, and usually such settlement is confidential, so we don't know how much Kun paid to Rogers. The court also considered three other factors of fair use, and they found that all these factors favored Rogers. One, the nature of the work copied was creative. Two, the amount copied was virtually all of the image. Three, Kun's appropriation harmed Rogers' potential market for art rendering. Right? It says that he actually hurt Rogers' money-making opportunity from his artwork. But please note, these three factors I've just mentioned does not apply to the defense of parody. In fact, later you will see some cases I'll show you. For parody to work, your audience must be able to see that you are obviously referring to the original work and making a comment out of it. Okay, next one. This is another case called Steinberg and Columbia Pictures. It's another US federal case. Saul Steinberg produced the 1984 movie called Moscow on the Hudson. Right? The one on the left is their poster. They were accused of copying from the view of the world from 9th Avenue, a work done for the New Yorker. Sorry, just now I think I got it wrong. Steinberg is the one that came up with the New Yorker's poster, and Columbia Pictures is the one that came up with the Moscow on the Hudson poster, which are said to be a copy of the New Yorker. So what do you think? Columbia Pictures say that they raised a defense of parody, of estoppel and leches. Let's not talk about estoppel and leches. Let's concentrate on parody. Now, to determine whether the defendant had copied the image, the court turned to the circumstantial evidence of excess and substantial similarity, like what we mentioned just now for Roger and Kuhn, excess and substantial similarity, comparing these two artworks. So first, the court found that there were ample evidence that Columbia Pictures have access to the copyrighted work of the New Yorker piece. The defendant actually admitted at trial that they had used Steinberg's poster as an inspiration for their own. As to the question of substantial similarity between the two works, the court asked whether an average lay observer would recognize the alleged copy as having been appropriated from the copyrighted work. Now, although it's acknowledged that the idea of drawing a world map, even from an egocentrically myopic perspective, could not be copyrighted. Right? Basically, by saying that, you draw a map, I draw a map. The map is, of course, has to be quite accurate, right? Depicting the real thing. That cannot be copyrighted. But in this case, the court found that the defendant had gone far beyond copying merely the idea of the Steinberg poster and had in fact copied its expression. The court actually went into the detail, say looking at the angle, the layout, the details of the 4 city blocks depicted, the use of the color on the horizon and the sky, the distinctive lettering used in both posters for name of places, as well as the title on the top, says the overall stylistic impression of the two works are very similar. So the court rejected the argument that any similarity between the works involve scène-faits. Scène-fait is a French term for standard themes. He says that, no, you cannot say that, oh, everyone who draws New York will do it this way because these are the standard theme when you depict a place. Just like if anyone wants to depict Penang, they would include the Penang Bridge, Komtang, maybe Kiloxi Temple, or maybe now the Ernest Zakarovich murals, right? So if someone include all these things in their creative work, you cannot say they copy from another person because these are scène-faits, a standard theme that will be used in the typical subject matter like this. But the court say that it is not, right? That poster for Moscow on the Hudson is not a parody because it also was not meant to satirize the Steinberg image, right? It wasn't referencing the original image, right? It was used as a movie poster. So the copyrighted work was not the object of the parody. So the appropriation of the image cannot be fair. I will skip this one. Just now we have gone a fair bit into what is meant by excess and substantial similarity. Look at this. In the Kuhn's case just now, the court defined parody as a new artwork that makes ridiculous the style and expression of the original. Right? A new artwork that makes ridiculous the style and expression of the original. If you look at these versions of Mona Lisa, you can say that they are actually making fun, right, of the original Mona Lisa. And therefore, if you want to consider whether this, I would accept this as parody. Right? In another case of Pillsbury Co. and Milky Way products, the court said this: we recognize that many parodies distributed commercially may be more in the nature of an editorial or social commentary than an attempt to capitalize financially on the plaintiff's original work. basically says that, for parody the work, usually it is more of a social or editorial commentary than for the purpose of making money. Now, but Mona Lisa, to illustrate the point of parody, may not be a very good one, because why? Leonardo da Vinci has died more than 400 years, right? He lived 500 years. He was born. Recently, we celebrated 500 years since his birth, right? Mona Lisa itself has no more copyright because the original author has died more than 50 years or 70 years. Therefore, Mona Lisa is already in the public domain. In fact, many artworks in museums are in the public domain for the same reason, because the author has already died a long time ago. So that is why when you visit a museum, museums usually allows you to take photos, right? Nowadays, museums allow you to take photos, but they say no flash photography, no tripod. Why? One, for safety reason. For another, basically museums don't want you to go into their museum and take very high quality photos of this artwork which are already in public domain. Because if you take a photo of the real Mona Lisa with your own equipment, you own the copyright. The Louvre cannot say that you stole the copyright, right? Because they don't own copyright anymore. So the only way for them to protect that interest is that they make sure that you cannot take high quality photos. Let me show you this one. This one is quite recent. The Chinese art professor Fan Yu. Fan Yu's work is the one on the left-hand side. That was done in 2017. And the British artist Russell Cobb did the artwork on the right in 2011, 6 years before. This case did not go to court, but if you look at the two works, you would say that there are substantial similarities, isn't it? I think that one is very clear. When Fan Yu was found out doing this in 2018, he was sacked from the university that he was working in. Right? And this before he was found out, he did a series of the work, and they became award-winning posters. He even got the Red Dot Design Award. And with this coming out, even that award was withdrawn. Right? So it doesn't pay to do that. Sometimes it does not have to go to court. Right? The court of public opinion, right, can cause you a problem. So it's not worth copying people's artwork like that. The next one we see, you know, the Chinese artist, very sought after, Ye Yongqing. Ye Yongqing painted the work on the left, and then it was found out that this Belgian painter called Christian Sylvain has done this work earlier. Again, if you look at the two works, although the figures may be different, the object used may be slightly different, but if you look at it, you look at the composition, where things are placed, looking at the colors, the lines, you can see very clearly that they are substantially similar, isn't it? So I think that copying is quite clear. Right? I think if it goes to court, Ye Yongqing will be in trouble. So when he was found out about on what he has done, he can only say that he was deeply influenced by Selvon's work. And it was last reported that Ye Yongqing was trying to get in touch with the Belgian artist. Since then, I can't find any information as to what happened after that. Of course, there were a lot of hoo-ha because Ye Yongqing was quite a famous Chinese artist. His work was selling very well. In fact, this work sold for 100 times more than the price of the original Selvon work. Right? So the irony of copyright infringement is that many times the copied work end up to be so much more valuable. You'll see more example of that happening. The next case I want to show you is the case of Carrier and Prince. Richard Prince is that famous artist. Carrier is the photographer who took these photos of some native people. So Richard Prince was sued. Now in 2011, the Court of First Instance in New York actually found that Prince's works were infringing. What Prince did was, you see, he painted on the original, on the photos, having the person carrying a guitar, having some colors on. So the New York court actually found that Prince was infringing the copyright of Carrier. Of course, that drew a lot of attention because Carrier, when he went to court, and when the court decided that Prince have actually copied and infringed his copyright, the court actually ordered the unsold works of Prince actually be impounded and destroyed. That's something quite severe. And the court found that the works were not transformative. It was a clear derivative, it says. And also that Richard Prince wasn't doing it to comment upon the original work. He just did it as if it's his original work. The case was very closely watched by the art world. Artists actually favored Prince's position, and photographers, of course, favored Carrier's position. In April 2013, the US Court of Appeal actually reversed the New York court's decision, finding that most of Prince's work were indeed transformative to a reasonable observer, and therefore it is fair use. In particular, the court found that the lower court was wrong in requiring that the appropriating artist claim to be commenting on the original work. Right? That is a requirement for parody, but not for fair use. And the court found that the work is transformative if they presented a new aesthetic. So the appeal court actually found 25 out of the 30 works to be clearly transformative and fair, and amount of fair use, and actually sent the other 5 paintings back to the New York court, saying, you go and practice, use our standard, and go and decide whether these 5 paintings are transformative or not. But before the New York court decide on that, the case was settled by the parties in 2014. Now, this one. The one on the right is Jeff Koons' work. Right? Jeff Koons is famous for appropriating images from popular culture or everyday object, right, for his art. Like casting a balloon dog made from precision engineered mirror polished stainless steel, finished with a translucent coating of high gloss paint. Right? This is what he did. And in 2013, his 10-foot tall balloon dog, they had another one, orange colored one, were sold at 58.4 million at Christie's, right? Then setting a new record for the most expensive work ever sold at an auction by a living artist. Actually, later in 2019, his stainless steel inflatable rabbit sold for 91.1 million at Christie's. Now, he also made Kun is a businessman. He also produced a lot of small balloon dog made of stainless steel. Right? And he sell these sculptures, small ones, for $7,000. Now, what happened was there's this company in Canada called Im Living. They made plastic balloon dog bookends that you see on the right hand side at the bottom, on the left hand side at the bottom. And those bookmarks are sold for $30. In 2010, Jeff Koons actually got a legal letter, what we call a cease and desist letter, issued to a store and gallery in San Francisco called Park Life. Park Life was selling these bookend dogs, balloon dogs, balloon dog bookends, produced by that Canadian company. And Jeff Koons actually sent them a legal letter asking them to stop selling and advertising the balloon dog bookends. Question: can Jeff Koons own copyright over the image of the balloon dog? Considering that this artist has based his entire career on appropriating pop culture, and he's actually been sued many times for appropriating others' copyrighted image, can he do that? Park Life wasn't going to be bullied, so Park Life actually got a free lawyer. And the free lawyer was saying that virtually any clown can attest no one owns the idea of making a balloon dog. The shape created by twisting a balloon into a dog form is part of public domain, you know, everyone knows how to do it. A famous clown called Funny Bone says clowns all over America don't understand why Koons believed he was the first artist to turn the balloon dog into art. So with the news of Jeff Koons' letter going out, actually the plastic bookend balloon dog sold very well. Right? Their business went through the roof. Park Life lawyer actually took the initiative and sued Jeff Koons' company in San Francisco's federal court, asking the court to declare that Park Life wasn't infringing on Jeff Koons' copyrights. Jeff Koons wised up and he settled the matter. Jeff Koons agreed not to pursue the gallery for the sale of the bookend, and the gallery agreed not to indicate that the bookends were by Jeff Koons, which they never did. Right? When they sold the bookends, they never did say that these are after Jeff Koons or copying Jeff Koons. So that was settled. Show you another Jeff Koons. This was quite recent, 2014. All right. The poster on the left is done by a French advertising artist called Frank Davidovici. He did this for a fashion company. And this was done actually a long time ago. That it was done in, I think it was in the 80s, right? The advertisement. And then the artist saw Jeff Koons' sculpture, the one on the right hand side, exhibited at the Pompidou Center in 2014. And he sued Jeff Koons for copyright infringement. Right? His work was created in 1985. Jeff Koons' work in 1988. The court case he only sued him in 2014. I think the reason is because he only found out so much later, and he can show that he only found out so much later. And the French court actually found against Jeff Koons again, and he was ordered to pay damages of 168,000 euros. Was it dollars converted? Yeah. So again, I think from that work you can very clearly see there is appropriation. Let's come back to Malaysia. So far, you notice you're not in Malaysia. Have you all come across this recent controversy? I think this one is still brewing. On the left-hand side, we have the Malaysian artist Izzat Arif came up with this artwork using Didi Yusof and add on the words, at the end of the day, art is not essential pun. I think this story came up from Izzat Arif's Instagram posting as well. Supposedly, Datin Vivi Yusof issued a legal letter to Izzat Arif asking him to remove this artwork that is saying that it's infringing copyright. Looking at this case, I think if you really go to court, I think Izzat Arif will stand a good chance to say that it is a parody. Because Vidi Yusof was at various times accused of plagiarism, of copying ideas from others, right? She was accused of copying ideas of, this one is called what? Sleepy Lama, Sunaru's complaint. You see the one on the right-hand side, the two photos. The one on the left is by someone else, and the one on the right is by Yusof. At the bottom as well. So she was accused of copying the ideas. So copying the idea itself, like I've mentioned just now, there's no infringement of copyright, right? But still, the artworks say that, hey, you've been copying ideas, and I think Izzat Arif was making a comment. At the end of the day, art is not essential pun. Of course, when Izzat did that, he was obviously also referencing the recent controversy where the National Art Gallery removed 4 of Ahmad Fuad's work from his exhibition entitled, At the End of the Day, Even Art is Not Important. So, of course, you know that those 4 paintings at the end after much hoo-ha was put back. So, this is one Malaysian example of art and copyright and work. Bad artist copy, great artist steal. This was attributed to Picasso. Bad artist copy, great artist steal. This quote is actually interesting because it actually nicely reflects the problem of dealing with art and copyright law, right? Many famous people quoted Picasso saying this, including Steve Jobs. In 1988, when an Australian newspaper printed an article that talks about lawsuits in the computer industry and the development of the Macintosh computer system, it was reported that Steve Jobs quoted Picasso defending himself. He said, "Good artists copy, great artists steal." But if you search on the internet, variation of this quote is variously attributed to people like Davenport Adams, T.S. Eliot, Igor Stravinsky, William Faulkner, and Picasso. So it nicely illustrated that very often copyright issue is not that straightforward. So bad artists copy, great artists steal. If you want to be philosophical about it, when someone copy your work and you don't think you want to take action, go to court, spend legal fees, then maybe you can say that imitation is the highest form of flattery. Someone wants to imitate your work because they are really like your work. Now, next. Does Ernest Zakarovich own copyright onto this mural of his boy on a motorbike? Or the other one, little children of a bicycle? Sorry, instead of showing you little children of a bicycle, I'm showing you this because this one is on my building. So, does Ernest Zakarovich own copyright of his murals, his famous murals? The short answer is he does not. Okay, he does not. There are exceptions to copyright. Just now we have looked at the exception of fair dealing, fair use, parody. Now, if some artwork is found permanently situated in a place where it can be viewed by the public, right? Ernest's work are all on walls of buildings by the street. Everyone can see it. So it fits this definition where the work is permanently situated in a place where it can be viewed by the public. Then the artist cannot enforce his copyright. There's no copyright in that. It makes sense. Such law makes sense because same idea, like just now we talked about buildings, right? So if there's a copyright belonging to a building, then you have a problem. You cannot take photos on the street of the building. So the law says that no, we can't have our society, community function like this. So if you put something in the public space permanently, then you cannot enforce a copyright. There's no copyright, right? But the law says that the artists own moral rights, right? Moral rights. What is moral right? It covers two aspects: the right to paternity and the right to integrity. Right? Paternity and integrity. Basically, the right to paternity means that the author has a right to be identified as the author of the work. So, meaning, if you see Ernest Zakharovich's mural in Penang, right, you can see them on postcards, on key ring, on books, on many things, right? Actually, they are infringing Ernest Zakharovich's moral right if they don't put Ernest Zakharovich's name on those products. Right? The moral right requires them to do that. Right? So that's one thing. The right to integrity, meaning that it protects the author's work against modification that will adversely affect his honor and reputation. So the Malaysian Copyright Act actually explicitly prohibits any distortion, mutilation, modification of the work if the distortion, mutilation, and modification significantly alters the work and adversely affect the author's honor or reputation. We come to this case. Have you seen this before? This is a huge sculpture by the late Datuk Syed Ahmad Jamal. In 1985, UMBC, the bank then, commissioned him to produce this sculpture. It was titled Puncak Purnama, Lunar Peaks. This huge sculpture was installed in a roundabout in Jalan Sultan Sulaiman in Kampung Matap in KL. The sculpture was presented to the city of KL as a gift from UMBC to the people of KL. In the year 2000, DBKL carried out what they call upgrading works to the sculpture. They removed the ceramic glass cladding of the original sculpture. You know, the original cladding was this ceramic glass, which was used by NASA to put on their space shuttle. And that was removed, and DBKL upgraded it by putting stainless steel covering the whole sculpture with this stainless steel that you can see on the right, without asking for Dr. Ahmad Jamal's permission or consent or even informing him. So Ahmad Jamal sued DBKL and he won the case. In 2010, the Malaysian High Court awarded him 750,000 damages. I think it was reduced by the Court of Appeal a bit, but it stands. That act of DBKL was infringing Ahmad Jamal's copyright. Moral right. Right. There's no copyright on it, but there's moral right. Unfortunately, the story does not end here. Ahmad Jamal passed away in July 2011, soon after the court case. On 1st of July 2016, Puncak Purnama was demolished by DBKL. DBKL was saying that the sculpture is now lifeless. Of course, the demolition caused an outcry among the members of the art community. We call it an act of institutionalized vandalism. It is a great loss to the nation's cultural heritage. Now, but the interesting legal question is whether the demolition of the sculpture has infringed the moral rights of Syed Ahmad Jamal under the Malaysian law. In the US copyright law actually specifically mentioned that any intentional or grossly negligent destruction of a work, right, is an infringement of the moral right of the author. But unfortunately, if you look at the Malaysian court case, the Malaysian law, it talks about modification. It talks about alteration. So the good question is in Malaysia whether this destruction of the sculpture infringes Syed Ahmad Jamal's moral right. I was told that the family actually got compensation in the end from DBKL, so there's not going to be a suit, so we won't know the answer to that question until another case come about. So 1st July 2016 became a dark day in the history of our country. And this tragic event illustrates to us how important it is for us to educate everyone, not just those in the creative industry, but also the public, and particularly those in power, on the importance of art, of culture, of heritage, and the rule of law in our country. Right, so that's all that I have for today.
Oh, okay, thank you, Mr. Lee Khai, for the very interesting, informative, and enlightening talk. So I think there is a lot of things being mentioned, informations that are new to us, to me mostly, especially. And I hope it shed some light to us, and it can help us gain knowledge or find out more informations what we should know to empower ourselves and as well to empower the public to elevate the value of arts. Okay, so now I'm going to open these sessions for question and answer. So I'll be taking questions both from Facebook, Arts USM Facebook, and also you can ask, participants can ask directly here. You can just turn on your microphone and your video, or you can ask in the chat box here. Okay, questions can be both asked in Bahasa Melayu and English. Okay, so while waiting for questions, so I have a few myself, okay, regarding the slides that you mentioned. So I got a list actually. Okay, number one, on the copyright of artistic work. So you mentioned ideas are not accepted to be copyrighted. So it mean that only finished work or tangible works, or if it's music, even if it's music, right? It's accepted to be copyrighted. What about sketches or like for architecture, blueprints and things like that? Can those be accepted to be copyright?
Of course, sketches, studies, anything that actually in a tangible form, all right, can be copyrighted. So when I talk about idea, is really if I tell you a story, okay, if I tell you a story and then you use my story and you turn it into artwork, or you use my story and you write a adaptation of that story, just like what Dan Brown did. Then I cannot accuse you of copying my idea, what I give you. But if I tell you that story and you copy down, you let's say you tape record that story, what I say, and you do a translate, then you are infringing my copyright, my performance of giving you that story. And if you're copying word by word, then you're infringing my copyright, right? But if you take the idea, the gist of what I'm doing and turn it into artwork, whether it's a written work or whether it's a visual artwork, then there is no infringement of my copyright.
Okay. All right.
So anything you put, let's put it simply, anything that you put on paper is copyrightable.
Okay. All right. So one more thing, one more questions. So when you say the artwork needs to be proven, it is yours. So what constitute the proof of that artwork? Is it signature or is it certificate of authenticity?
Basically, it's first in time. When you talk about copyright, it's basically who comes first. So that regulation gives an avenue for us to register, but I don't think it's very well used. You can actually register and that provide a prima facie proof. Traditionally, there were also people who actually affirm a statutory declaration. Right? They make a statutory declaration before a commissioner for oath and say that I declare that I work 1st of January to year 2000, I did this work and this is the work. Right? Then that is a timestamp. Right? So it's all about time. Then you show proof that, 1st January year 2000, you already came out with this. So if anyone come out with it after, then you're infringing my copyright. So it's about time.
Okay. All right. So that one does have to have a proof, some kind of proof, right?
Yes.
Okay. Actually, we do that in USM, copyright students' work and lecturers' work. And you mentioned that the works being done by lecturers belongs to USM. So that is actually true. So I did some research and I asked the legal office of USM, and they mentioned that if you're not just lecturers, you as students as well. So the artwork, although the author is by students or lecturers, but the owner is USM. So I think that applies to a lot of other institutions as well, right?
Unless otherwise agreed, but student may be a bit tricky. If you're
Why
under
is that?
employment, under the act is very clear. If you're under the employment,
Okay.
then without saying, you the person who commissioned it or your employer owns a copyright. Student, I think it's debatable.
Okay. So we can go through that afterwards.
I don't know whether there are, during the enrollment, there are any legal small prints that say whatever you do, whatever you
Okay,
produce
so
in the school belongs to the school. Yeah,
okay,
there
so
may
we
be.
can we can they can still argue that, right?
It all depends on the law. So it's those are the default position unless otherwise agreed upon by the parties. Right? Both sides can agree to a different thing.
So I have a question from Fawaz Halim from Facebook. Bagaimana pengkarya boleh melindungi hak cipta mereka? Ada tak sebarang akta atau agensi kerajaan yang menyediakan khidmat ini?
Just now the regulation that I mentioned, you can register it with that under that regulation.
I think it's called Pesuruhjaya Sumpah. Is it correct?
No, just now Pesuruhjaya Sumpah is what I mentioned just now. There's the other way. People will affirm a statutory declaration before the Pesuruhjaya Sumpah Commissioner for Oath. That one is the one to say, I timestamp, I've done it on this date and this time, and this is my oath. That regulation that I mentioned just now in one of my slides, that's a different platform.
All right, okay.
Basically, it's first in time. Okay, one very not too difficult way is actually take photos of your work, lots of photos. And nowadays, digital photos, they are all timestamped. Worst come to worst, you can really prove when it was taken. So like I said, it's always first in time, right? So if you've taken the photo and you keep it and you have the digital timestamp as to when it was taken, then you have proof of when your copyrighted work came about.
Some kind of documentations proof, right? Or maybe some artist or designer, they post it on their Instagram account and they keep it there.
Exactly.
Or maybe if they don't want to make it public, they can just private it, but just keep it as their own archive, personal archive.
Social media is very useful. Instagram, in fact, is the world's largest gallery.
Yeah.
Dr. Tetriana, I have a question for Mr. Lee Khai. What
Yes.
about fair use in using the image of a work for a publication? The fair use, what is fair use in this case? How fair is fair?
Okay. I think usually especially in your academic publication, you're quite safe, right? Because when you are talking about it, you are commenting it in relation of whether it's theme or subject matter, your research, you are quite safe. You start going towards the gray area. Let's say, I come out with a talk. Another person come out with the talk. A third person come out with the talk, and then you put all this talk together and you publish a book. All right? Or some people copy wholesale various educational materials. One chapter from author A, one chapter from author B, one chapter from author C, and you put them together as your materials. That would be problematic, right? But if you are referencing, even putting a photographs of the artwork in your research work, that is quite clearly fair use, or in Malaysia it's called fair dealing.
Just say if the publisher or the holder of the copyright holder argue the fact that you are publishing and the fact you are getting money out of the book that you publish. How is that situation? Is it macam like they have a fair case on you or not? I mean, the fact that you produce a book, academic and stuff like that, but then you're selling it,
Yeah.
Not much.
My advice usually is don't risk it. All right, don't risk it. Then you usually go to the person and ask for permission. Right, and then don't forget to protect moral right also. You always want to have footnote or attribution, as acknowledgement as to whose work is it, where you get it from. Don't forget, if someone do a painting, all right? The artist own the copyright. If a photographer come and take a photo of the artwork, let's say with the permission of the artist, the photographer also owns a copyright of his photo. All right. So if you want to use the photo taken by the photographer of the artist's work, it is best that you get permission from the photographer if it can be shown that it is very, if you can prove that you actually use his photograph. So you would want to do that, right? To make sure that you don't get into trouble. So when in doubt, get permission.
But this also means that the photographer should get a permission from the artist, right? Before the photographer take a picture of the artwork.
Put it this way, whether the photographer gets permission or not, he owns copyright to his photographs. But his copyright is subject to that artist's copyright.
Okay, right. Okay. So one thing I remember you talk about when you sell artwork, does it mean that you sell the copyright as well? Does it automatically means you sell the copyright?
It does not. It does not.
Okay.
So like what I mentioned just now, when you buy an artwork, buying the object, the canvas, the frame, right? The paint on it, you own that actual painting, but you don't own the copyright unless when you buy, you actually have a contract with the gallery or with the artist to say that you're selling me your copyright as well. So a lot of time people will share the copyright. I license, you have a perpetual license to use. So artists can do that. I can give you a perpetual license to the museum, meaning you museum can use it. I artist can also use it when I want it. Yeah, so you can do that.
So that one will include like legal administrations and fees and all that, or is it just a simple like perjanjian?
It can be a simple letter to say that the sale of this artwork includes the copyright. It can be as simple as that.
Okay.
You don't always need to spend money on lawyers.
Okay. So when you say lay observer in the court, what does it mean by that?
The court sometimes have to set standard. So the court the judges put themselves in the shoe of a common man.
Okay.
And say if a common man will think like that, then it passed the test. So it's a bit artificial, but you have to do such intellectual exercise. What would a common man think?
Oh, okay.
So a common man would think that. So that means you don't need an expert to come and tell you, oh, you copy how many percent, what is similar, what is too close. You don't need an expert to tell you that. Any lay person can say that, hey, you put the two together, I can see that it is one copying the other.
So that is like a legal term, right?
It is the way where judges process how they decide things like that. So they come out with various tests. So this test is what does a common person, a lay person think.
But it's justified by the court of law.
Justified by the court.
All right. Okay. So I have question here from Facebook. Izzat Arif. Okay. Yeah. Let's go to this one first. Two questions. First, Izzat Arif versus Duck. If not plagiarism, the photographer was accused him of not asking permission from them. Can they actually sue Izzat if he didn't ask their permission? So maybe they want you to elaborate on Izzat's positions here. How can Izzat is Izzat's situation in jeopardy? Can they sue him?
I think first, I think after Izzat was threatened with a legal notice, I think he took down that work that he did. For him, what is available is the defense of parody. So the defense of parody is now different from just now what we talked about fair use or about derivative work. He Izzat clearly took the photographs, just like what Andy Warhol did to various things. Right? The photographs, he did change the color and everything. But the important thing is that he was making a comment about the original work. So he will stand or fall on whether what he came up with amounts to a parody in Malaysian law. All right. And for me, I think he stands a good chance.
Yeah. I think it's quite,
because of the social commentary that he was making on the original work, or what it is it about.
It has to be an obvious parody, right?
It is an obvious parody. So using the actual image itself is not wrong. Right? But it's different when you are not doing that's why you remember Jeff Koons case, he lost. The Columbia Picture case, they lost because they were not doing a parody, they were copying it for their own commercial use. Arif's work obviously wasn't for that.
Okay, so a note to Izzat. Okay, so another question.
Not online, is it?
I don't think so, but yeah, but this is live on Facebook and recorded. Hi, I am Sean New, a PhD student of mine, and I have a question in the context of the extremely frequent globalization of images and information exchanges. So if you're a painter, you will often see pictures or symbols of other people's work in your mind while painting. It seems impossible that the works of art are completely different in idea and painting method. If you are a creator of artworks, how can you learn from others the works without touching the boundaries of copyright? Where is the dividing line between them? So yeah, the question between referencing and copying and imitation and things like that. I
hope that what I shared with you just now, the various examples showed to you, it may not be a very simple thing, right? The court does not have a simple job in deciding whether it is generative, whether you have copied. That's why you talk about accessibility. Just now, this questioner asked about accessibility, so easily accessible, right? So accessibility very often it's not an excuse anymore. It's very easy to show that you have access to it. Then it is the similarity, how close it is. Right. So remember Richard Prince, he just added some drawings on the original, but the court found that it is transformative. Right? In Jeff Koons one, although one is a sculpture, one is a photo, copy, one is blue, and stylistically there may be difference, but the court can say that it's so similar. So like just now when you see the few on Ye Yongqing or the other Fan Yu's, individually, if you look at the element of the artwork, right, the copying work, if you look at the individual element, it's still fine if you take it out. But when you put those elements together, the composition is clearly shows that you are copying that work. Then you are in trouble. So
that's quite
easy
obvious,
question.
isn't it?
Those are very obvious. So let's put it this way: obvious case we can easily catch it.
But on artistic side point of view, but as professional artists or mature artists, I think you are able to differentiate between referencing and copying, because you are often referencing, and then you will know your limitations. I think a lot of mature artists will know their limits. So as a PhD student, you should know as well, Sean. Okay, from Isabel, when you buy the artwork and copyright, does that mean it's all right when the buyer then decided to mass produce the work? For example, printing it on merchandise.
Go back to the same question. When you buy the artwork, whether you bought the copyright. So if you buy an artwork off the wall without any contract, you cash and carry and buy the artwork, you don't own the copyright. You cannot make merchandising of it. Right? So for example, I collect art. I have a fair number of art, and my office every year I produce a calendar. I use artwork from in my collection. I always ask artists permission. I get their permission, right?
Okay. So when you get the permission, so if you got the copyright, you can either decide to have the keuntungan distributed or not, right?
The exclusive use, like just now what we mentioned the first few slides about what you can do with the copyright. So an artist sells you the copyright, then you are like that artist now. All right, you can do whatever the artist can do with copyright.
Okay. So another question by Ku Chiangjin. Can a painting style or a unique painting technique be copyrighted?
Depending on what you mean by style, right? You know, everyone does. Okay, if you do impasto technique, you can say that it's very close. You know, the way the field is like, you know, teachers and students work. All right, very often they are close, but I wouldn't call them copying. Right? That okay, you must differentiate between the moral world and the legal world. Right? So some work can be obviously, you know, you are not creative. You are copying the idea of another artist, right? You may not be accused of infringing copyright, right? But the art world will say, this guy is not creative lah. He's obviously copying someone's style, right? So there are two different things: the moral world, the moral evaluation, and the legal evaluation, right? So very often stylistically you can copy other people's idea. Right? That is why Picasso is quoted to say that good artists, bad artists copy, great artists steal. Steal meaning basically, I think what he means is you're stealing the idea, right, and making it your own rather than copying the style. When you're copying the style, in those examples that I gave you just now, it can be copyright infringement, right? But sometimes it may not amount to it. Not easy question. You really need to see the visual examples.
Yes, have to show the samples.
Because it is qualitative, it's not quantitative.
Okay, soalan for USM. USM boleh wujudkan satu kajian berkenaan hak cipta intelek khusus dalam bidang kreatif. Cadangan from Fawaz Halim. Yes, that would be interesting. If there are students who are interested to do this, yeah, you are welcome. And we can have Mr. Lee Khai to advise us as well. Even Fawaz, you can do that. Okay. So it's 7 now, 5 minutes. Okay, so I think I'll end the session now. Okay, so there are a lot of things that we should know about law, which can protect us, designers and artists. And artists and designers should know and be more knowledgeable of copyright law to protect not just themselves from being plagiarized, but also from accidentally or unconsciously plagiarizing other creative works. Okay, so with that, I end this session, and thank you again, Mr. Lee Khai, for your talks. Okay, good night, everyone.